What to expect at the initial hearing. The initial hearing, or as some states refer to as arraignment, is the opportunity for you to find out what you have formally been charged with. When you enter the courtroom, you'll be given a copy of the charges that have been filed against you. You need to review that to make sure that your name, address are correct and spelled correctly. You also need to review the charges filed against you. After that, the court will play a video for you and everyone else that is there for their initial hearings. Most likely, there will be several others having their initial hearing at the same date and time as you. The video will explain to you your constitutional rights. It will also explain to you all of the possible offenses ranging from C misdemeanor all the way up to murder and the possible penalties and fines that come with those offenses. Now, everyone will not apply to you. You'll need to listen specifically for which level of offense that you have been charged with. After the video is done, the judge will enter the courtroom and he or she will eventually call your name, and you'll need to approach and sit at the table, and the judge will ask you if you have reviewed the charges against you, if your name and address are correct. He will also then at that point in time ask you if he needs to read that to you, or you can let the judge know that, no, I do understand what's been charged against me, you don't need to read it to me. The judge will then go ahead and enter a plea of not guilty. That is automatically done. That gives you an opportunity to talk over with your attorney what your best option is, whether that's to take a plea agreement, take it to trial, or some other resolution. The judge will also at that point in time give you all of your future court dates. That will include your omnibus date, which is a date that's only important for the attorneys. Will most likely give you a pretrial date, a final pretrial date, and a jury trial date or bench trial date, depending on what level of offense you've been charged with. All of those dates we will explain to you at a later time and what those mean. But that's all that's going to happen at the initial hearing, most likely. Now, some other things that could happen depending on your particular situation. If you've been charged with an operating while intoxicated or an OWI, most likely the judge will also inform you at that point in time that your license is going to be suspended, and he needs to notify the Indiana BMV of that suspension. However, if we are with you, we will ask the judge to stop that, stay it, freeze it, whatever term that you want to use. We'll ask the judge to give us 10 days to file specialized driving privileges if you are allowed to statutorily. Some operating while intoxicated offenses do not allow for specialized driving privileges, but if yours does allow for it, we will ask the judge to stay that suspension, give us 10 days to file the paperwork, and at that point in time, the judge will set a hearing to determine whether or not you should get a specialized driving privilege. Other things that could happen, if you're still in custody, meaning you're still in jail, bond will be an issue. The judge will most likely discuss what your bond is, and we may or may not have an opportunity to ask the judge to reduce your bond at that point in time. The judge may tell us we need to file paperwork asking for a separate hearing to determine whether or not your bond should be reduced. Other things that could be discussed at that point in time are protective orders. Sometimes the particular offense that you've been charged with may require that you be served with a protective order or a no contact order. That is something that will also be taken up at the initial hearing. But short of that, that's all that's going to happen at your initial hearing. It really is a quick and simple process, very painless. It's primarily scheduling. It's all about getting all those future court dates. If you've been charged with a misdemeanor, we will likely file a motion to waive that initial hearing, meaning you don't need to go to it, we won't need to go to it. The court will simply send us all of those future court dates. However, if you've been charged with that operating while intoxicated, we will likely need to go so we can ask for the specialized driving privilege. By statute, if you've been charged with a felony, you must appear for the initial hearing. But again, that's it. That's all that's going to happen at your initial hearing. If you're out of custody, you will not be taken back into custody. You will not be going to jail that day. It's primarily just to get those future court dates.